pleasurable parts of my work at Stanford and the work of some of my colleagues, Diane and Elsa and Shalini in the attendance tonight, is advising students on scholarships such as the Marshall. And a few weeks ago I tried to find a Marshall that I'd worked with many, many years ago at the University of Tennessee, before I came to Stanford. And I did find him. He's now in the Midwest, a faculty member in Indiana. And he looked at our website and he made this quote, and I think it's a quote that says why it's so wonderful, the work that we do, the work that the Marshall Commission does, and the wonderful work of the scholars. And he said, "I see that you have the great good fortune of helping people to a once-in-a-lifetime opportunity. And over the years, it's been a real pleasure to work with scholars. Some I'm reconnecting with tonight. We've also been very lucky at Stanford to have wonderful supporters who serve on campus panels and assist students and send them forward to the regional committees. So again, it's a pleasure to be involved in this event. It's also a great pleasure to introduce the next speaker. We've been lucky over the years to have wonderful consul generals in San Francisco who have been very supportive of the Marshall Scholarship. I think we're especially lucky with our current consul general from the United Kingdom, located in San Francisco, Priya Guha.
Thank you, John, for that very kind introduction. And just may I add my thanks to you, John, and of course to Stanford University for hosting us all this evening. And to add my personal welcome, in particular to all of you Marshall Scholars here this evening. I've met people from the intake of 1957. I've met people, I think 8 of you from the intake of 2012 over there, you know who you are. I suspect being here in the balmy temperatures of Stanford University doesn't take many of you back to your time in the UK, but I do hope this evening will bring back many fond, if not warm, memories. It is, of course, a real honour to have Kathleen Sullivan here with us this evening to celebrate the 60th anniversary of the very first Marshall's class. In my role as British Consul General, I have had the privilege of meeting some of the world's most influential people, from the world of politics, from the world of business. But my personal highlight is something I get to do each and every year, which is to sit behind a table as a member of our Marshall Scholarship Selection Committee and see person after person walk through that door for interview who has the most amazing personal story to tell. Each year I know that those are the people who will influence the future, and that is why Marshall Scholarships matter. When Marshall Scholarships were established, the UK and the US had emerged from the Second World War, one of the most devastating conflicts the world had seen. They had emerged as proven allies, as proven friends. Marshall Scholarships helped to strengthen that friendship, and they've been doing that now for 6 decades, a remarkable legacy by any measure. The US-UK relationship is as strong as ever, not only between our two governments, but also through business-to-business partnerships, educational and research collaborations, and arts and cultural exchange. The Marshall Scholarship Programme has helped foster the breadth and depth of the US-UK relationship by enabling future American leaders to study at any of our universities in the UK. And indeed, with the world's top 10 universities to choose from between us, that's a pretty impressive list to choose from. By sending Marshall Scholars to some of our best universities, we hope to give them an appreciation for British people, for British culture, for fish and chips, for Yorkshire pudding. And when they're there, we hope they will make lifelong connections with their UK equivalents, Britain's leaders of the future. Supporting talent is just a really good thing to do. But it needs to be talent from the true breadth and depth of the United States. Education and opportunity should never be the privilege of a few. My colleagues from the British Consulate General and I are very focused on working to ensure that all of the higher education institutions we meet know about Marshall Scholarships and tell their brightest and their best about them. And we thank many of those in this room for their help in spreading this really important message. For these such international experiences are one step along the path to success. Past Marshall Scholars have become prominent in every field: business, in science, in education, in health, in journalism, in government. Scholars, of course, include Kathleen Sullivan, who you'll hear from later on this evening, but also LinkedIn co-founder Reid Hoffman, the New York Times columnist and three-time Pulitzer Prize winner Thomas Friedman, and of course our wonderful, the late Ray Dolby, whose legacy as both the inventor of Dolby Sound and to the Bay Area community will be forever lasting. My colleagues and I from the British Consulate are immensely proud to continue our work with a programme that's brought over 1,700 brilliant scholars to the UK over the years. But our job in doing that is made so much easier by the community of Marshalls here in this room tonight and throughout our consular region and across the US. So many of you support us and help us on every step of that way, and thank you from all of us for all that you do. One of those very Marshall alumni who I've been privileged to get to know and call my friend is the wonderful President of the Association of Marshall Scholars, Mr. Bob Gray.
Let me add my warm welcome to everybody. Over half of tonight's attendants are Marshall Scholars, and you should all get in the habit of identifying yourself not as a former Marshall Scholar or as a past Marshall Scholar. Once a Marshall Scholar, always a Marshall Scholar. And I need to thank two people in particular who helped put this event on tonight. We are an all-volunteer organization at the moment. We are looking to professionalize and hire an executive director, hopefully this year. But two of those volunteers are Betsy Scherzer and Ben Heineke of the San Francisco. And now it's my great pleasure to introduce Kathleen. Kathleen M. Sullivan has had a historic career as both a professor and a practitioner of U.S. law. Now partner and chair of the National Appellate Practice at Quinn Emanuel, Urquhart & Sullivan, LLP, the world's largest business litigation firm. She previously served as a professor of law at Harvard and Stanford Law Schools and as dean of Stanford Law School. The first woman dean of any school at Stanford, she is now the first woman named partner at any Am Law 100 law firm. Over her 3 decades in academia, she taught constitutional law to a generation of law students and was elected to the American Academy of Arts and Sciences and the American Philosophical Society. Now a nationally prominent appellate advocate, she argues a wide variety of cases in the U.S. Supreme Court and federal and state courts. The National Law Journal has named her one of the 100 most influential lawyers in America. Kathleen holds a BA from Cornell University, which she attended as a Telluride Scholar, an MA from the University of Oxford, which she attended as a Marshall Scholar, and where she obtained first-class honors in PPE, and a JD from Harvard Law School, where she won the Ames Moot Court competition. Now, not included in this stellar biography are some other aspects of her service to the Marshall community, and I quote from the recently published directory last year, where there's a brief history of the AMS. Kathleen was part of a team, quote, that produced the AMS's first electronic database, the resurgence of the biennial directory, and most illustriously, the enlistment of His Royal Highness Prince Charles as the honorary royal patron of the AMS. In celebration of the relaunching of the AMS, the British Embassy hosted a gala in February 1989 with gloved butlers, intergenerational speeches by scholars, and Prince Charles himself in attendance. Following the event, Sullivan was elected AMS's next president, end quote. I should also mention her service on regional selection committees. She has served in both Boston and San Francisco, where I got the pleasure to meet her. She's one of the most talented human beings I've ever had the pleasure to know. Please join me in a warm welcome for Kathleen.
John, Priya, Bob, thank you for those introductory remarks, and to my friend through Marshall Scholarship Business, Bob Gray, thank you for that generous set of remarks. I'm extraordinarily honored to participate this evening in the celebration of Great Britain's generous gift to now some 1,400 young Americans who got the chance, as I did, to study at British universities for the Marshall Scholarship, Britain's great and generous expression of gratitude for the Marshall Plan aid. Receiving a Marshall Scholarship to attend Oxford from 1976 to 1978 was one of the greatest experiences of my life. It made a profound difference in my life, for which I remain immensely grateful. And my memories of those years remain quite vivid. Now, 40 years later, and well into my career as a lawyer, I'm even more moved by the unique experience I had and the formative experience I had to be exposed to the great relationship between the United States and the United Kingdom. Now, having studied in Britain, we were never quite the same, and here I think I speak for all the Marshall scholars in the room. We were changed by the experience, and we were like the people in that great scene from the 1936 Hollywood movie that made Humphrey Bogart a star. It was called The Petrified Forest. It involved a scene in a cafe in the eastern desert of California where the young Betty Davis greeted a urbane, somewhat mysterious gentleman played by Leslie Howard. And he spoke with tones that weren't quite the eastern desert accent, leading Betty Davis to say, "Are you English?" To which Leslie Howard said, "No, you might call me an American once removed." So it was with us Marshall scholars. Now, at Oxford, it was my privilege to study, as Bob mentioned, PPE, philosophy, politics, and economics, and I can tell you I still lie awake trying to solve the problems my tutors posed to me, like, do prawns have feelings? But I went on to study law, and I chose as the topic tonight, specifically the points of commonality and difference between the US and UK legal traditions. Now, of course, you might say, well, what are the points of difference? They, of course, have much in common. And to begin with, they have in common the common law. Both our traditions are those of the common law, the judicial articulation of precedent in a continual ratcheting back and forth between well-developed general principles and new particular factual situations. The judicial opinions by common law judges that guide future actions between the parties often reflect multiple judicial voices, typically contain subtle nuance that help narrow the scope of the decision, and usually cannot be reduced to any simple formula or bright line rule. Now, in this respect, both of our legal cultures, the US and UK legal cultures, differ markedly from civil law traditions. Now, I've had occasion since I've been in law practice sometimes to have to study the civil law. I had occasion once to go to Paris to depose French law professors on the meaning of French contract law. It was a tough job, but somebody had to do it. I had the opportunity to go to Milan to learn about Italian bankruptcy law in connection with a case we were pursuing in the United States. And on both those occasions, I was so profoundly struck by the reverence that the civil lawyers had for the well-thumbed, used versions they had of their civil code, which they carry around like a sort of legal Bible. And I was kind of envious at how they had such formal reverence for the civil code and how they seemed to find in it a kind of textually bounded certainty that is unfamiliar to US and UK lawyers as common lawyers. Both our traditions have, in addition, in common, an immense respect for the independence and authority of the judiciary. In contrast, in much of the world, courts are understood as mere extensions of the other branches of government, and often as their subordinates. When once I had occasion at an international legal conference that brought judges and lawyers from around the world, from Britain, the United States, from Germany, France, Ireland, Australia, South Africa, Israel, judges and lawyers from around the world, and I found myself in the extraordinary position of being in the minibus going between events next to none other than Justice John Paul Stevens. And I thought, well, what anodyne thing can I ask him that won't cause any conflict? And I decided to just ask him at a conference like this, what is it about the United States court that leads your counterparts in other countries to admire us? What is the thing about American courts that judges in other nations most admire? And Justice Stevens answered without hesitation, the ability to have our decrees obeyed. And the same is unquestionably true of the pronouncements of Britain's own High Court and Court of Appeal and Supreme Court, though not true of every court around the world. Now, those are the common features. The common feature of the common law, the common feature of the authority and independence of the courts. Now let me turn to some of the differences. There are differences. For example, we do not wear horsehair wigs to court. And we rely a great deal more on written than on oral advocacy in our litigation culture. And I learned as much back when I was a young law professor. I was dispatched on a trip to London to speak at a black-tie dinner at the Inns of Court in front of the Harvard alumni of London. Another tough job, but somebody had to do it. Now, I had as my host a QC, a Silk, a Queen's Counsel, a very distinguished barrister who had an additional degree from Harvard. And the day after the talk, he took me to the Royal Courts of Justice, where I saw an extended oral argument in front of the High Court. It was quite remarkable. The oral argument went on for some hours. Here were these bewigged barristers speaking so eloquently in front of the justices. And at the end of the argument, the justices declaimed from the bench the decision in the case, speaking in full paragraphs the decision in the case, reaching forward for volumes off the bench to read in quotations from precedent. I was flabbergasted. And when I exclaimed to my host how impressive all that was, bemoaning the fact that our oral arguments are so short and our decision time from the courts is so long, he replied to me, commenting on the differences between our cultures, "Yes, we in Britain have always wondered why you Yanks rely so much on the briefs and so little on the oral arguments when you speak so well and write so execrably." I begged to differ, but I didn't get very far. Well, turning from that to some deeper differences, let me turn to our civil justice systems, our civil legal systems, which, well, in fact, bear very little resemblance at all. This was pointed out to me early in my career by a most unexpected encounter at the very event that Bob Gray just called to your memory from February 1989, the first great gathering of the Association of Martial Scholars after His Royal Highness the Prince of Wales had graciously agreed to serve as our honorary patron. The Martial Scholars asked to gather from far and wide, from around the globe, to the embassy in DC for a gala event, and Prince Charles was there, and we got to meet him in person. Now, before the formal ceremony, in which, as the new president of the Association of Martial Scholars, it was my privilege to hand the Prince some memorabilia of the great General George C. Marshall, I was just one of many other excited marshals on the rope line, coming up to meet the Prince. who had the most extraordinary gift for coming up with something interesting to talk to every one of us about all our different professions or professional goals. So when it was my turn, I stepped up. I came, said, "Sir," bowed, curtsied, did whatever I thought I was supposed to do. And he said, "What's your line of work?" And I said, "Well, I'm Kathleen Sullivan. I'm a law professor at Harvard Law School." To which the prince said, "Ah, law professor, don't you think Americans are terribly litigious?" Well, I wasn't expecting to have to talk about that topic, but I replied that I did not. And really, compared to the scope and heterogeneity of the American Republic, one needed lawyers. Remember what Tocqueville said, after all, in 1835, in Democracy in America, we lack an aristocracy, we lack a common religion. We need lawyers, in fact, and lawyers in America serve important functions in enabling commerce and resolving social conflict. To which he said, "Well, I think Americans are terribly litigious." I was convinced that if I had more time, I could have convinced him, but the line was restless and I had to move on. Well, a few years later, we had another gathering of the Association of Martial Scholars, and again, Prince Charles agreed to attend as our honorary patron. And again, the rope line gathered, and again, I excitedly looked forward to my greeting the prince. I got closer. I remembered him. I don't think he truly remembered me, because when I got there, he said, "What's your line of work?" I said, "I'm Kathleen Sullivan. I'm a professor at Harvard Law School." He said, "Don't you think Americans are terribly litigious?" Now, the longer I have practiced law, the better I have come to understand Prince Charles' point about the exceptional nature of American civil litigation. The United States offers a unique legal elixir to potential litigants around the globe. It offers the prospect of civil juries, liberal pleading rules, broad discovery, class actions, punitive damages, and above all, the American rule that each party bears its own legal fees and costs so that the loser has no obligation to pay for a failed or meritless lawsuit. No wonder we might seem terribly litigious, and no wonder U.S. courts are a magnet for disputes that involve foreign parties in foreign jurisdictions. Now, I think something about the prince's observations may have gotten to the American Supreme Court, because one of the signal trends in the Roberts Court over the last decade may seem to be an acknowledgement that Americans are too litigious. Across a wide range of subject matter areas, the Roberts Court has raised the bar to U.S. civil litigation by tightening standing requirements, requiring more particularized pleadings, limiting private rights of action under federal statutes, saying the government can sue but private litigants may not, holding state law lawsuits preempted by federal statute, and enforcing the presumption against the extraterritorial application of U.S. law by limiting U.S. lawsuits involving foreign conduct. I'm describing a whole host of cases, but they have in common this recognition that perhaps civil litigation is too easy in the United States. Now, while this line of decisions has not made Americans by any means non-litigious, it has moderated our tendency to seek resolution of quite so many social and economic issues in court. In other areas, however, there remain deep and persistent differences between the U.S. and UK legal traditions, and I'd like to focus in particular on our two different approaches to constitutional law. To begin with, the United Kingdom does not have a written constitution. We have a very terse one, and most industrialized democracies do have written constitutions. The United Kingdom does not. Instead, the British Constitution arises from a series of statutes and judicial interpretations and political conventions without benefit of a foundational document. That the US began with a written constitution is not surprising, for after all, our national founding was forged in revolution. And so we had to start, in a sense, from scratch with a charter of a new government. The founders also made the US Constitution deliberately difficult to amend, with Article 5 requiring the extraordinary exertions of supermajorities, so extraordinary that they've resulted in only 27 amendments in the more than 225 years of the Republic. 10 passed all at once with the Bill of Rights, and 3 passed in the aftermath of the Civil War, all in one fell swoop. In contrast, the British Constitution, given its unwritten nature by definition, is inherently more flexible and amenable to revision in light of changing circumstances or changing social or political attitudes. But these differences should not be overstated. The commitments set forth in the text of the US Constitution are, for the most part, both broad and vague. Due process, equal protection, freedom of speech, regulation of commerce. And these broad and vague commitments, having little specified content, have required judicial elaboration over time to adapt that text to changing circumstances. We thus have seen rulings by the United States Supreme Court that effectively bring about the informal amendment of constitutional text through evolving judicial interpretation. For example, in a series of decisions, the court has held that women are protected against gender discrimination by the same brief equal protection clause that gave newly freed slaves rights against race discrimination, even though, despite many attempts at enactment, an equal rights amendment dedicated to the end to sex discrimination was never passed. It was passed out of various Congresses, but there were never 38 states to ratify it, at least not all at one time. So there's an informal amendment that says gender discrimination is covered by the Equal Protection Clause without an equal rights amendment. And the court has adapted the Fourth Amendment to modern technology by holding, back in the 60s, phone booths, or more recently, the data stored on smartphones and cell phones, to be the virtual equivalent of the papers, houses, and effects that the Fourth Amendment provided the police may not search or seize without a warrant. You might call it common law constitutionalism, this kind of informal amendment through judicial interpretation. And when you think about it, that's not all that different, even with a written constitution, from the tradition of British constitutionalism, which is largely judicially elaborated. Now, just as there's a kind of common law element to American constitutionalism despite the written text, there is conversely a textual element to the British Constitution despite its unwritten nature. After all, remember Magna Carta? 1215, the barons at Runnymede asserting against King John the rights of self-determination that said that certain kinds of due process could not be transgressed at will. Or the Petition of Right, a document drafted by the leaders in the House of Commons in 1628 in a response to an attempt by King Charles I to impose taxes on pain of imprisonment without parliamentary authority. Or the Declaration of Rights of 1689 that accompanied the end of the Stuarts on the throne, asserted a variety of what it called ancient rights and liberties that the monarch could not trammel at will, including a right to free elections, a right to bear arms, and a parliamentary right to free speech. So there are 3 documents, 3 texts that are part of the British Constitution. And so explicitly did these British documents set forth American-style rights to self-determination that I once relied on them in a debate with a team of British barristers at a joint US-UK in-of-court event held in Philadelphia. Now, I'll tell you what the assignment was. The proposition at issue was, this House believes the Declaration of Independence was an illegal document. Guess which team took each side? As you might imagine, the British team took the affirmative position, the American team the negative. I had the privilege of arguing for the American team with the late, great Judge Pollack from the Eastern District of Pennsylvania and Dean Levy, a former judge, now at Duke Law School. And we got up to fight against these formidable, eloquent, silver-tongued British barristers who said that there was no real necessity for the overthrow of the British crown. Now, when we got up, I would say, perhaps not really leading in the argument in the debate, I remember Magna Carta, Petition of Right, Declaration of Right. We could find in them the very origins of the Declaration of Independence, and somehow we convinced the audience that, with the benefit of those 3 documents, that in fact the Declaration of Independence actually was just relying on British law after all. We won the debate. We had a hometown advantage. It was Philadelphia. the time, maybe the British Constitution is not quite so unwritten after all. More recently, of course, the United Kingdom's accession to the European Communities Act of 1972 subjects British law to certain European conventions that operate akin to a written constitution, the European Convention on Human Rights, for instance. And Parliament's enactment of the 1998 Human Rights Act actually incorporates into British law the rights expressly set forth in the European Convention. It makes them enforceable under British law by British courts, who then must pay attention to European precedent. Now, British decisions, as a result of this kind of importation of a kind of written constitutionalism, you sometimes read British decisions now, and they don't look so different from US decisions that are applying the power of judicial review that American courts assert under a constitutional text. So we're not that written. The British Constitution is not that unwritten. The dichotomy between the written and unwritten constitutions is not as stark as it first appears. But despite these possible similarities and convergences between US and UK legal tradition, there are some deep differences that remain between the US and UK legal cultures, and I would like to spend the remainder of the talk discussing some of our different approaches to some issues of individual rights, approaches that are deeply ingrained and reflect our different constitutional culture and sensibilities. I'd like to focus on freedom of speech in particular. Now, the US Supreme Court has robustly enforced the right of free speech protected under the United States Constitution's First Amendment. It wasn't always thus, not so much in the first half of the 20th century, but the second half of the 20th century reflects a series of free speech decisions that are ever more protective of freedom of speech, no matter how hateful, how offensive, how subversive, as long as it isn't a trigger to imminent violence. And the Roberts Court in the last decade has been particularly receptive to First Amendment challenges. In case after case, in speech cases before the Roberts Court, you know what's going to happen. The speaker almost always wins. Now, I knew they would falsify this proposition just today by deciding a case that held that, yes, states may regulate judicial candidates who solicit money in judicial elections. So the speaker doesn't always win, and there are some other exceptions. But for the most part, if you're looking at a free speech case in the Roberts Court, and somebody's challenging a restriction on speech or its related rights to symbolic conduct or freedom of association, the speaker will almost always win. And I think actually later generations will look back at the Roberts Court and think about it as one of the most speech protective courts in United States history. And there's actually a kind of, it's something that unites the two sometimes described as ideological ends of the court. The so-called left of the court loves free speech to the extent it brings about the goal of equality by helping dissenters fight off the orthodoxy of the majority. And the so-called right wing of the court loves free speech because it fosters the value of liberty by protecting people exercising private speech with private resources against the overbearing tyranny of the state. So this is an issue on which the court is often lopsidedly united, not always, it's sometimes divided, as it is, for example, over campaign finance, where the justices who like equality are for regulation and the justices who are for liberty like speech. But largely, free speech cases on the Roberts Court produce lopsided majorities. Now, to other nations, our robust protection of freedom of expression often seems extravagant. For example, unlike other nations, the United States resists the notion that any speech is so beyond the pale, so hateful, so offensive, so falsified by history, as to be categorically unprotected under their constitutions. Other nations often assume that because speech conditions action, speech enculturates people and teaches them how to act. Other cultures often assume that because speech is the bedrock of action, you must regulate speech prophylactically to prevent social harm. A Yale law professor named Alexander Bickel wrote famously at a time when there was a lot of campus unrest and he was sympathetic to its suppression. He wrote in 1975, "Where nothing is unspeakable, nothing is undoable." And that, in a nutshell, expresses the commitments of a lot of other European and other industrialized nations' constitutions that allow the suppression of certain kinds of unspeakable speech. A number of European nations, for example, banned the display of Nazi symbols, banned the denial of the Holocaust, criminalized speech directed at racial vilification. But the US free speech tradition takes the contrary view, that speech and action are sharply separable. And that was the point of the exercise at Oxford about do prawns have feelings. Speech and action are sharply separable, and what government may regulate is action, but not the speech and thought and exchange and association that leads potentially to action. Late 20th century United States Supreme Court decisions systematically narrowed the categories of unprotected speech until they were almost so narrow as to be meaningless. For example, it's traditional under American constitutional law to say that incitement of serious harm or violence may be regulated even though it constitutes speech, and yet the court in a series of cases after the Red Scares of the 20s and through the McCarthy era of the 50s and through the civil rights marches of the 60s, 50s, and 60s, the court came to a resting place where it said that incitement can be punished only if it is directed at and likely to cause imminent serious violence. In other words, words have to be literally the trigger to the mob on the brink of action, not just words that might help to foment thoughts that lead to violent action. The same thing with other categories of unprotected speech. Courts never said that so-called fighting words are protected, but over a series of cases it narrowed the concept of fighting words that could be prohibited to essentially a face-to-face provocation to a brawl. Not something that creates insult or anger, but really just a kind of face-to-face flinging of an insult. And I could go through the same exercise for obscenity, libel, other unprotected categories of speech. The story of the late 20th century in the US Supreme Court was to narrow these unprotected categories ever further. And that's why in the United States, we may have judicial decisions that protect the symbolic conduct of flag burning, burning a US flag in protest. Or that, although this was never finally resolved by the Supreme Court, the controversial series of decisions that allowed a neo-Nazi group to symbolically march through the village of Skokie, Illinois, wearing brown short shirts and goose-stepping and bearing swastikas. That sort of symbolic conduct, no matter how hateful, how offensive, how likely to inflict emotional distress, to inflict anger and alarm, the American tradition increasingly protects every form of such speech. You might say, well, don't we have a rather conservative court now, and isn't the Roberts Court different? And the answer is no. In fact, if anything, the Roberts Court over the last decade has accelerated this trend or extended it still further. In case after case where new government actors came forward and said, well, can't we regulate this kind of offensive speech? And surely this kind of speech, which produces so much social harm, we can regulate this one. And can't we carve out another category of unprotected speech? And each and every time, the Roberts Court, in lopsided majorities, has said no. It has declined to denominate any new category of speech unprotected by the First Amendment. In a case called United States against Stevens in 2010, an 8-to-1 majority invalidated a federal criminal prohibition on the sale or possession of depictions of animal cruelty, a market in so-called crush videos that prosecutors wanted to stop as a kind of unusual form of obscenity. But because it was directed to the subject matter of depictions of animal cruelty, the court subjected it to a kind of strict review and struck the law down. A year later, in a case called Snyder against Phelps, the court had to confront what to many is the odious spectacle of an organization called the Westboro Baptist Church. It was on the steps of the Supreme Court yesterday, which has a practice of directing its ideology that blames tolerance of homosexuality for a lot of modern ills in United States life, had a practice of expressing this anti-gay message at military funerals. One jury, led by prosecutors in a state where the military funeral of a young man who died for his country was targeted by the church, decided that this was too much and gave a verdict that allowed $11 million in damages against the church for the torts of invasion of privacy and infliction of emotional distress. But when it went up to the US Supreme Court, an 8-to-1 majority overturned the damages award and said you can no more fine speech through civil damages than punish it through a criminal law. And the court held that this is public speech on a matter of public concern in a public place, directed generally at the public. It is not an interpersonal form of harassment of a person like an obscene phone call. And in that context, it upheld the speech and struck down the damages award. In those cases, there was only one justice who echoed Bickel. Justice Alito dissented alone in both cases, saying crush videos, speech targeting this message at a military funeral is unnecessary to bring about the speaker's purpose, and it's not a civilized society that should tolerate it. Just one vote for Bickel, or the approach that the European nations take. A year later, in a case called Brown against Entertainment Merchants, again, this time from California, the government said, can't we regulate this kind of harmful speech? What about violent video games when sold to minors? And the court said, though, well, there may be social problems that come from conditioning young people to take human life through simulations on a repeated basis. The science isn't clear, but one thing we know is that there's not enough proof here to justify this law, and the court refused to recognize a new unprotected category of depictions of violence aimed at children. And then the next year in United States against Alvarez, once again, the government, this time the United States Congress, came forward and said, well, surely we finally found a form of speech that can be deemed unprotected. False claims of receipt of decorations of military valor, False Valor Act that said that you can't lie about having received the Congressional Medal of Honor. There was a prosecution in which a plea was taken. It became the test case of a man who had declaimed at a local government board meeting that he'd received the Congressional Medal of Honor, and he talked about his heroics, none of which was true. It was all factually false. That was not in dispute. 6-3, the Supreme Court of the United States invalidated the conviction and the statute, saying that a criminal prosecution of false claim of receipt of a military medal of valor violated the First Amendment, noting that false statements of fact may not be a thing of beauty, but they can be regulated in narrower ways. They can be regulated by limiting the law to people who intend to cause harm or do cause harm. So a series of cases in which the US Supreme Court upholds free speech rights and says, in the United States, we just don't call these categories of speech unprotected. Now contrast with American rulings, contrast such American rulings with a few examples from British law. And here I think you'll see the point that whatever the similarities I tried to sketch earlier, there are some deep differences in our constitutional cultures. Consider the 2006 Terrorism Act, for example, in which Britain decided, in the aftermath of the terrible events of 9/11 and their aftermath in Britain, criminalized any statement, I quote, that is likely to be understood as a direct or indirect encouragement to the commission, preparation, or instigation of acts of terrorism. Now, so far, not so different from American law. After all, the US Supreme Court, notwithstanding all the other decisions I described to you, did uphold a prosecution, has upheld prosecutions for the material support of terrorism, even through the purported support of peaceful activities of terrorist organizations. So not so different, but then here's the part that really diverges from US law. The 2006 Terrorism Act goes on to define such a direct or indirect encouragement of terrorism as including any statements that, quote, glorify the commission or preparation, whether in the past, in the future, or generally, of such acts as worthy of emulation. Now, I told you earlier about United States constitutional law narrowing the definition of constitutionally prosecutable incitement to speech that is directed at and likely to produce imminent serious violence. The British Terrorism Act would not survive that clause. The glorification clause would not survive review under American First Amendment challenge. An American tradition would be skeptical of such a broad, vague term as glorifying terrorism as worthy of emulation, out of fear it would give too much discretion to police and prosecutors and immigration authorities. Nor would US constitutional law, for the same sort of reason, permit a 2006 amendment to the British Public Order Act that added the offense of, quote, stirring up religious hatred. Now, I say this even though it might well be that American political majorities would gladly support such laws. What I'm describing is just the constitutional obstacles they would face. Or consider such decisions as arise under the British Public Order Act in the wake of recent events. Consider a case, for example, a 2011 High Court case titled Abdul versus Director of Public Prosecutions. This was an appeal from a criminal conviction of alleged protesters, people who claimed they were protesting British military involvement in Iraq and Afghanistan. And what they were prosecuted for was standing next to a parade of British soldiers and shouting at them words like, British soldiers are murderers, baby killers, and should go to hell. These words, the trial court held, qualified under the Public Order Act as violations because they qualified, as the Public Order Act proscribes, as threatening, abusive, or insulting words that are uttered, again, I quote, within the hearing or sight of a person likely to be caused harassment, alarm, or distress thereby. Now, again, I told you earlier about the Westboro Baptist Church case. A lot of the things said in the Abdul case to the British soldiers were almost verbatim, the same as were said at the military funeral, as to which tort damages were prohibited. So the US constitutional precedents like Snyder versus Phelps would not countenance such prohibition of public speech in a public space, no matter how truly alarming and emotionally distressful its communicative impact. Indeed, the striking similarities between Abdul and the Westboro Baptist Church case put in stark relief the difference between United States and American and British approaches to the regulation of offensive speech. Now, in reflecting on these remarks for tonight, I thought, well, how do we explain, given all the commonalities between our cultures, these rather divergent approaches? And at the risk of greatly oversimplifying, I think the answer lies in something that's as deep as different conceptions of individual rights in relation to the state. American constitutional conceptions situate the individual right holder in a kind of opposition to the state. It understands rights as prior to the state. It understands the state as something that comes along and represents a potential source of tyranny and oppression and interference with individual freedom. Or as you might say, we never really got over the list of grievances in the Declaration of Independence. Government is Leviathan, it's a threat to a private order. British constitutional conceptions reflected in some of these free speech cases I've described are quite different. I think they situate the right holder not in opposition to government, but as part of a community whose good is facilitated and protected by the state. The state acts to protect individual liberties. Individual liberties are part of the fabric of state protection, not in opposition to state tyranny. And on this view, the state is not the enemy of individual rights, but their facilitator and protector. And on this view, rights like freedom of expression are never freestanding or absolute, but always to be assessed in proportion to other rights and interests that the government is likewise charged with protecting. Now, you might call that the proportionality principle. And of course, it's familiar in the express language of a number of other constitutions and conventions. Outside the United States, the Canadian Charter, Canada can never decide is it more like the US or Britain, so this shouldn't be a surprise, but the Canadian Constitution guarantees enumerated rights, or France I should add, the Canadian Constitution guarantees certain enumerated rights and freedoms, but in its proportionality clause, as some call it, it says that it protects those rights and freedoms subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. But in the very clause, it contemplates that some of these restrictions might be reasonably justified or demonstrably justified. Or consider Article 10 of the European Convention on Human Rights, which is the Freedom of Expression Clause. It provides that freedom of expression is protected, and of course that binds Britain now through the Human Rights Act. But in Article 10, Section 2, it goes on to say, now, wait a minute, freedom of expression also, and I quote, carries with it duties and responsibilities, and I quote, may be subject to such penalties as are prescribed by law and are necessary in a democratic society. And it goes on to enumerate what some of these necessities might be: the prevention of national security, the prevention of personal insult, the protection of dignity and autonomy of the person. So in Canada and in the European Convention, you don't see a right as against a hegemonic tyrannical government. You see rights as understood as part of a fabric of protection in which there might be rights on both sides. Rights to expression and rights to autonomy and dignity. Rights to expression and rights to the security protected by the state. And indeed, when the High Court in the Abdul case, the British parade protest case I described a moment ago, they reached, as they had to, the question of whether the prosecution under British law was now compatible with the European Convention on Human Rights. And in concluding that there was no incompatibility at all, the court said that we think that this speech was, echoing the trial court in the case, so unreasonable and disproportionately expressed that, in effect, the speakers had forfeited the protection of Article 10. So I started with the points of commonality, the common law and the respect for the independence and authority of the courts. I talked about the differences: horsehair wigs, different approaches to litigation, written versus unwritten constitution. I then said maybe the differences aren't so great after all. We have aspects of our Constitution that are effectively unwritten, and the British Constitution has foundational documents too. But I come to the end in thinking that there are some deep differences between American conceptions of individual rights against the state and the kind of conception of individual rights as part of the fabric of the state that unites more the British, Canadian constitutions and the European Convention on Human Rights than it unites any of them with the US Constitution. But I come at the end to the place we began. And here I really think I can say that the US and the UK view of individual rights in relation to the state absolutely converge. And I come, of course, at the end to where we began, which is the Marshall Plan. Now, I used to challenge my students. I had a long and wonderful career as a law professor that I'm so grateful for. And my students often wanted to do civil rights and civil liberties and human rights, and I would challenge them. I would say, well, what do you think is the greatest contribution to human rights in the 20th century? And they would often think of, well, prosecutions of people who had committed atrocities against mankind, or civil lawsuits trying to get damages for the victims of human rights relation. They thought immediately about litigation, prosecutions and litigation. And no doubt, as a result of the wonderful gift I was lucky enough to have with so many other people in this room of the Marshall Scholarship when I was very young, I thought, no, that's not the right answer. There is one answer, and the correct answer to the question, what was the greatest contribution to human rights made in the 20th century? And it is the Marshall Plan. And I would remind them of General Marshall's words in announcing the plan in his Harvard speech in June of 1947. He talked about waging war not on any nation or culture, but on poverty and hunger and devastation. But he didn't just talk about those economic aspects of the plan in isolation. No, not at all. What he did is he talked about individual rights in relation to the state as part of this fabric that I've described as somewhat antithetical to the American conception. He said that the purpose of the Marshall Aid, and I quote, should be the revival of a working economy in the world so as to permit the emergence of political and social conditions in which free institutions can exist. Surely, whatever I've said to you tonight about our different legal languages, General Marshall spoke that sentence in words that speak to our common legal language. Thank you very much.